Good afternoon. I want to thank everybody who joins us. My name is Ola Atamanova, and I'm happy to see you here in Ukraine Media Center, Ukraine Forum today. It's been 10 years of the war, and today is day 443 of the full-scale invasion of our homeland by Russian aggressor. And all of us during this war, we keep talking about the punishment, about the adjustment to be brought in this global subject of achievement of justice. And today we will be talking about the ways to expedite the confiscation of aggressors' assets, the tools that we can use. We will talk about the legal component and the priorities. So our speakers today are Inna Bohatykh, Director of Sanction Policy of the Ministry of Justice of Ukraine. Right by my side is Hlib Kenievskyi, Head of StateWatch, Roman Steblivskyi, an analyst at StateWatch, and joining us online is Serhii Milman, founder and CEO of YouControl. I'm happy to see all of you here. Miss Inna, let's start probably with you. Let's talk about the legislative initiatives to be implemented to expedite the process. What is the status as of today? What are we working with? What things work? What things do not work? Please. Good afternoon, dear colleagues. Good afternoon, dear journalists. I'm happy that indeed the matter of sanction legislation and enforcement of the assets of those who support Russian aggression, I put it intentionally in words like this, because it can be not only Russians, it can be also citizens of Ukraine and citizens of other countries. So yes, this is a resonant issue for the time being, and thank you for paying attention to this topic, for inviting us, and we're ready to talk openly about it. In brief, I will just tell you how the sanctions mechanism works and about the problems that exist. So let's start with enforcement of the assets of the entities which end up under sanctions. Well, it's possible when they are being sanctioned after the 24th of February, or sorry, 24th of May, because that was the day when the Ukrainian legislation on sanctions was effected. Those are the sanctions of enforcement of assets of the persons or entities which end up under sanctions. Is the unique situation in the world, so we have to have such instruments available. We have to create such instruments to reinstate the justice and to achieve some compensation from the persons that support Putin's regime in front of citizens of Ukraine for everything that is going on in Ukraine now. So this sanction emerged on the 24th May 2022. So the first premise is the blocking sanction after this date. Another conditions as per the law is the presence of assets with that entity, and based on our practice, we're talking here about the assets which are located in Ukraine. well, there is no mechanism to enforce the assets abroad for the time being by us, so we can only enforce the assets in Ukraine. The premises are described in the law. There should be certain preconditions. They are being checked by anti-corruption court. And talking statistically, we have 24 NSDC resolutions after 24th of May, within the framework of which there are sanctions imposed to almost 2,800 entities, including individuals and legal entities. As we were talking in the Center of Anti-Corruption, we were discussing this topic and we were asking why are there so little resolutions. So I'll tell you how those persons are being inspected and how the president's order emerges in the public plane about affecting of NSDC resolution on imposition of sanctions. So the Ministry of Justice is vested the title to inspect the entities for the presence of such assets, and each resolution is being processed from the point of view of the assets that are available to some persons, the persons that are mentioned. So out of 6,800 persons to whom the sanctions, or the entities to which sanctions are imposed, their assets, we identified assets with only 250 entities out of 6,800 inspected. So they may mean big businesses, but also those may be small assets about which there is information on their registers. But anyway, there's the there's the entity under sanctions, and its assets may be enforced in favor of the state of Ukraine. So talking about some significant groups, today we have information about 30, maybe up to 50 assets that can be called significant, and in relation of which the blocking sanction is affected. So here in the beginning we have a wide funnel, but as they go through this bottleneck, as we screen them, we see that for the time being the number of entities who possess some significant assets amounts to 30 to 50. And the Ministry of Justice has the information about 230 to 250 more entities which possess significant amounts of assets. For the time being, Ministry of Justice submitted 20 suits. The day before yesterday there was yet another case with regard to the Duma deputy Tsekov, who voted in support of all the laws and resolutions of Russian Federation, which resulted in full-scale invasion and recognition of Zaporizhia and Kherson regions and part of other temporarily occupied territories of Ukraine as parts of Russia. So it won't be difficult to prove his guilt. His pro vote is just a sufficient evidence. But as to the property, his real estate, we don't see it as some significant asset, but still we have proven evidences. We think that this person should not avoid liability anyway. As to the significant suits, I'll get back to them. Ministry of Justice submitted 20 applications, 19 of which were satisfied and 17 of them were affected. The resolution on Deripaska is not yet affected. As you know, the situation is complicated because it's been 4 months of court consideration of the proceedings. Meanwhile, the court code sets forth shorter periods for consideration, and we would like the court hearings to be appointed sooner, and we would like this case to be finalized sooner, because those assets which are about to be enforced in favor of Ukraine, they should have been working already for recovery of our economy and support of our armed forces. So to make sure that the proceeds from those activities are used to counter Russian aggression. Another resolution which was not yet affected is with regard to Salda. It was brought not so long ago. Ministry of Justice is about to submit an appeal because the anti-corruption court refused to enforce the assets of Salda's daughter, and Salda still has the right to dispose of his assets through his daughter indirectly. Ms. Rina, when we talk about those 17 cases which were already affected, so what amounts are we talking about here? We are being frequently asked about the amounts, but the mechanism of assessment, it does not exist, so we could submit the suit. But talking about the figures that show up in the media, Deripaska's assets are assessed at the amount of about $10 billion. Well, the property of Yanukovych, which was enforced, for example, those reserves like Mezhigirya, Sakhalucha, those are billions of hryvnias. In Yanukovych's accounts, there were 30 million hryvnia enforced. They were arrested but not enforced before, and they were enforced upon our application to the High Anti-Corruption Court. The monies were transferred to the accounts of the state of Ukraine. Then there were funds of Shelkov enforced in different currencies, approximately 50 to 60 million hryvnias, which are already transferred to the Ukrainian accounts. But there are still funds that are in the account with the bank, which is under liquidation procedures. So mechanism is quite complicated to receive those funds, to have them transferred to Ukraine, to accounts of Ukraine. But here we're talking about 14 million hryvnia more. I cannot tell you the exact amount for the time being that can be viewed as enforced in favor of Ukraine. There is no such assessment so far, but we keep working, we keep spending money on paper, on post services, and for salaries of our team, but hopefully we still keep working with profit, so to say. Well, you mentioned that the number of cases is from 30 to 50 and the general is up to 250. So your ministry already works with all open sources. Have you processed all of them, or there is still some work to be done in this area? Will this number increase? Well, the number may increase because the information varies. We receive new responses, and this number is just the number that I can name today. Moreover, NSDC intensively takes new resolutions on sanctions of more and more entities, so the number of such entities with assets in Ukraine will increase definitely. You've just mentioned it right. Are all of the open sources processed, or can we orient in those or line at those numbers? that we expect to get 250 cases from High Anti-Corruption Court. But again, getting back to what I mentioned in the beginning, every case should have the connections of the persons or entities under sanctions, and the connections between entities under sanctions and those assets. So when we talk about big businesses and some significant assets, there is usually no straight connection between such big businesses and entities under sanctions. Those are indirect connections that should be proved in the courts. This is why the court control is very important in this regard, to make sure us as the state that we're doing the right thing, enforcing the assets of the entities under sanctions in our favor. After the court identifies that connection of that significant asset with the persons or entities under sanctions, but it's a number of indirect facts, the number of legal and entities and individuals whose roles in those chains sometimes are minor, and there's a lot of steps to be connected between each other to make sure that the High Anti-Corruption Court comes up with the judgment. But again, we have, say, entity under sanctions. I can say openly that Kyiv, it's quite an interesting personality. There are assets in Ukraine. She was residing here, she had businesses here, and she still has assets in Ukraine. What she has done, her policy is passive. She does not justify, but neither she supports the aggression. But still, her stance is not proactively Ukrainian, and this is why sanctions can be imposed against her, because by her participation in concerts and other public events she justifies the behavior of Putin and the aggressor country. Whether the sanctions can be imposed to her as a confiscation of assets, that's an interesting question to me. For example, this is why we will go to the court to see whether there are enough reasons to enforce her assets in Ukraine. But again, this information regarding her activity, her support, this is what we get from the law enforcement agencies. It's a big piece of work, and submission of those suits, it does not only depend on the Ministry of Justice, but also on the investigations that were going on before Ministry of Justice starts playing its role in this chain. And it also depends on whether we can obtain some faithful information. This is why, as we consider the case of Karolina, we will find out what were her statements. They will be analyzed, and if there will be enough reasons, she will be yet another person in whose relation there will be a suit, but otherwise the reasons would be insufficient, and we will ask the High Anti-Corruption Court, and they will tell us that the reasons are insufficient for sanctions. So talking about 250 entities about whose assets we have information, it doesn't necessarily mean that there will be 250 judgments with enough evidence and proofs. So we may be told that the person did not commit enough actions that could evidence that their assets may be enforced. Thank you very much, Mr. Hlib. We know that StateWatch developed an online tool to analyze the confiscation of aggressors' assets. So please tell us about this work. How does it help to our Ministry of Justice, for example, and in principle, how does it help us to have those assets enforced. Good afternoon. Thank you for giving the floor to me. I would like to discuss the words of Ms. Ina about the amount. You asked what is the amount of assets or which are enforced or can be potentially enforced in Ukraine. I would like to comment it on behalf of StateWatch Information Center. So as the representatives of the civil society, we see it as strategic matter. We see it as a strategic matter just in a view that we can eradicate Russian businesses from Ukraine so it doesn't influence cultural, information or political life in this country or any other areas of life which in our opinion were saturated by the influence of Kremlin through Russian oligarchs and businessmen here in Ukraine, including those companies and names that were already named today here. They were used to influence the Ukrainian agenda. As to the register, we will present the register of Russian oligarchs. My colleague Roman Steblivskyi will do it, but I would like to tell you its story. So understanding the challenges faced by the Ukrainian state and the Ministry of Justice as the responsible body, the body responsible for enforcement of assets, and in front of NSDC as the key body for imposition of sanctions on the entities which are of threat to national security, we were understanding that it's necessary to create an instrument that could identify what can be enforced from whom and so on and so forth. So we pledged the support of our foreign colleagues, the Prague Center for Civil Society and the analytical platform YouControl. Serhii Milman will tell us today about his contribution to identification of Russian businesses in Ukraine. So we prepared this register where we gathered the information about Russian oligarchs. We counted 53 of them out of Forbes list 2021. So during the lucky years of Russia before the war, Forbes counted 53 such big businessmen who turn out to have assets in Ukraine, and you're gonna be surprised to find out that among such names as Friedman and Deripaska, there are dozens or a couple dozens of persons who are not so public, who can only be recognized by Russian ear, but even they have quite a broad range of assets in Ukraine, like shopping malls, hotels, mining companies that can influence the policies of entire regions in Ukraine, entire sectors of economy. So 53 persons out of that Forbes list, they have companies in Ukraine, and those companies should be enforced like first thing because they are in possession of the richest people of Ukraine, of Russia, excuse me, and the richest people in Russia are one of the instruments of Kremlin in this war that they're waging here and other wars that they're waging all around the world, and maybe future wars that they are about to start waging. We calculated the assets of those companies. Their evaluation amounts to 6 billion hryvnias, but that's only formal value, and in no case we can rely on it to evaluate the real cost of this business, because we already mentioned today the assets of Deripaska, for example. They are not in the best economic condition for the time being, and Ukrainian government has to take good effort to relaunch the operation of Mykolaiv clay factory that is being returned to state property. So it's not about economy so much as about the national security, to remove Russian capital from taking political decisions in Ukraine. And to summarize, I would like to stress that, in our opinion, the process should be parallel for search of traitors among Ukrainians, and the assets with Russian roots in Ukraine, the assets that should end up under sanctions for their anti-Ukrainian activity, because it's more of a question to NSDC list. We don't see a lot of infamous names and such Ukrainian actors as Portnov, Kyiv, Sivkovich. They deserve to end up on the sanction list so that Ministry of Justice in Ukraine and other bodies of Ukraine can evaluate whether their assets can be enforced. And also there are certain Russian businessmen who stay in Russia, pay taxes there, take part in government bids in Russia, but at the same time they have assets in Ukraine and they are not under sanctions so far, and we hope and we will take effort to make sure that they end up under sanctions shortly and their property can be enforced and forwarded for the reconstruction and recovery of Ukraine. So I would ask Hlib to keep the microphone and ask him whether your analytical work is it also parallel with the work of the government authorities. You have very firm results, very solid results, and the synergy of work of civil society and the government usually results in something powerful. Does your analytics, comments, information is taken into account by the government? Is there some communication in this level? Well, I like joking that there is the demand from the civil society and we keep the government authorities in tone. We kind of require some activities to be exercised by the government. And talking about the sanction policy, we request in public and non-public space, we provide the preconditions to make sure that those persons end up under sanctions. We communicate with the security service of Ukraine, anti-corruption agency, but at the same time, in my opinion, our active information cooperation with the Ministry of Justice in Ukraine, it's to demonstrate, including to the government, that this matter of enforcement, it should be top priority. It should be top priority to make sure that all those actors, Russian, Ukrainian, Belarusian, who are of threat to national security of Ukraine and who end up in the sanction list, to make sure that they are deprived of economic assets in Ukraine the soonest possible. Well, I would really like to thank journalists for their proactive position, because to add to what Hlib just said, the investigator journalist work is of great use to us because they dig profoundly into details of those cases, and it happens frequently so that sometimes recently there was an investigation by Serhii about the case which is about to be submitted to the court, and we received the communications from the Center of Anti-Corruption, and obviously all that information, it does not go to the court directly, but that's the direction we should start going, we should start developing in our work. So I urge everybody who has some relevant information, who knows about the circumstances that may be of evidence or activities of any persons under sanctions, any connections of the entities under sanctions, please let Ministry of Justice know. It's not being put in the table, it's inspected, it's been checked, and then communicated and fed back, so we inform the public about the results of our work. And also I would like to thank the system of YouControl, with whom we cooperate from the very first days of establishment of our department, because they have very cool analytics, and that analytics is available in the product of this company, and the way the analysts of YouControl work in some cases, we were receiving the expertise of this company, which was invaluable in taking those decisions and bringing up those judgments which were already affected. Thank you, Mr. Roman. So let's proceed to the presentation of registers. Good afternoon, my name is Roman Steblivskyi. I'm the analyst of StateWatch. If you can put my presentation on the screen. Thank you very much. So what we're talking about, so this is the short training. We talk about the systematizing of arrest and process of confiscation. Like Hlib mentioned, we've checked Forbes rating 21-23, and we were searching for the persons who possess some assets in Ukraine. And then we understood that, first of all, almost all of the persons on the Forbes list, they are sanctioned in Ukraine, including 53 Russian oligarchs. And we identified that they have companies in Ukraine, obviously different companies with different price and who work in different sectors of economy, but as a benchmark, as an opportunity to focus on those people, we created this website, this register. There we talk about two processes. We talk about confiscation of assets in favor of Ukraine within the framework of the sanctions law and resolutions of anti-corruption court, and about arrest of the companies. Some of the companies are under arrest, some of them are transferred to ARMA. So there is information about those companies too. The register looks just so that we already mentioned the corporate rights, that amount is formal, it shouldn't be considered in all the cases, and this is my request to the journalists. Please be aware that those figures are not final. So as we proceed to the page of some specific oligarch, specific person, we can see some blocks of information, like general figures, like his amount of assets in Forbes, his amount of assets in Ukraine, and the date they end up on the sanctions. So they ended up on the sanctions back in October during this first sanction package. Then we see the status of the assets, and the idea is not to search for that information all around the media, all around the news, but to have all the information concentrated in one place, and so that in brief you can understand what kind of person it is. In our descriptions we were trying to give some short information about what that person is doing and why, in our opinion, they are responsible for the actions of Russian regime in Ukraine. As to the list of assets, it's very convenient. We can check the status of the assets that they possess in Ukraine. In this case, it's about confiscated assets, but in other cases there may be multiple cases arrested / managed by ARMA or not confiscated. Then there is information about the companies themselves. There is a brief reference so you can understand what kind of companies are they, which sector of economy they work in, and we appreciate the contribution of YouControl, who provided us with this brief information. Also, you can proceed to the YouControl, clicking on that link, and check the historic links of that company, its historic connections, and so on and so forth. On that very same page of the company, you can check another important information. It's why we added this company to the list. So the connection, what Ms. Ina mentioned, why this company and how it's related to this or that person. We used a number of sources there, whether it's YouControl or some facts disclosed by the law enforcement or the government, or sometimes the facts from the court judgments. Sometimes we were relying on information of the investigative journalists who reasonably described that this or that person is associated person, affiliated person, like a wife or another relative. Also in the managers section, you may see whether the asset is arrested or confiscated, and sometimes it's important to understand in the context of arrested assets who is the manager of an asset. And in after confiscation, they may be different government authorities to whom those assets will be transferred to. Thank you very much, Mr. Serhii. I hope you're with us. I would like to give the floor to you. Ms. Ina mentioned about your invaluable contribution to this effort. Maybe you may add something to tell us how YouControl is involved in this process. Good afternoon to everybody, and thank you for invitation to this event, not only to this event, but to all this effort on the search and confiscation of Russian assets. In fact, among others, there are good news that yesterday there was the first case, the resolution of the Prosecutor General of the United States on the transition of the confiscated assets to Ukraine, and it says that it's the first swallow, and maybe we will have to track not only the assets arrested in Ukraine but also in the other countries as well. As to our work, from the beginning of the full-scale invasion, we reoriented to search the Russian trace in Ukrainian businesses. And for the time being, the analysts of YouControl identified about 25,000 legal entities which are connected to Russian Federation and Belarus. So we started from 5 risk factors which are reflected in the system. Now it's 9 such factors, the main of which are when a beneficiary or an owner or affiliated person of the legal entity is the citizen of Russian Federation or Belarus, or they're otherwise connected with the financial and industrial groups in Russian Federation, or a banal risk factor when there is word Russia or Russian in the name of the company. Also, we trace the connections with non-friendly countries which vote against Ukraine in General Assembly of United Nations: China, Nicaragua, Cuba, North Korea, Syria, and so on. So all the companies that we found, they have this connection with Belarus and Russia. We forwarded this information to law enforcement agencies, and as it was mentioned before me, we have certain results. But the state register was absent of the arrested assets. It should have been opened, for example, if ARMA is more transparent, but it's still cool that StateWatch team has undertaken this function, and they started making a product that allows the society to control the arrested assets, because we all understand that in the perfect world, those assets, thanks to the control of the public, should be transferred to Prozoro sales and sold with maximum efficiently, and then those money should be forwarded to armed forces of Ukraine or to the recovery effort, but used efficiently anyway. As to our participation in this project, we appreciate the invitation to get engaged, and then we were provided the list of Russian oligarchs, and we were able to find which assets exactly belong to them in Ukraine, and that was probably our contribution to this joint effort. Generally, we are ready to continue to cooperate and to provide all the necessary information to the Ministry of Justice and StateWatch to make sure that the process of confiscation remains efficient and the assets are being transferred for the purposes of recovery of Ukraine. Thank you very much, dear colleagues. If you have any questions, please join our conversation. Good afternoon, Elena Litvinenko, Ukrinform. I have a question to Ms. Ina. You mentioned 230, 250 assets which were identified, but can you tell us which out of that number are they legal entities or are they individuals, and who of them are Russian citizens, who of them are Belarusian citizens? And another question is, how exactly can we use the sanction of assets enforcement if those persons were already sanctioned before the 24th of May? Thank you for the question. I'll tell you directly that we don't segregate the entities under sanctions by nation, because that number 230, 250, it also includes the citizens of Ukraine. So I cannot tell you exactly who of them are Russians, who of them are Ukrainians, or who of them are Belarusians. We only consider them as the people who support the aggression, so their nationality doesn't really matter in this regard. Well, until the 24th of May, well, first, until the 24th of May, we had a different sanction in place. The blocking sanction, it was restricted to a certain extent, and it did not contemplate the possibility of blocking of assets which are indirectly owned by the persons under sanctions or entities under sanctions. So now we see that this practice of blocking is applied to them once again, but in the broad, so to say, in expanded mode, when we can confiscate the assets not only owned directly by those persons, but also owned indirectly when we have some corroborated information about such connection. So in this new expanded edition, we apply this new mechanism, we get certain authorization, I mean the Ministry of Justice, and we apply this enforcement sanction. Good afternoon, Любов Величко, розслідування. I have 5 questions to everybody, and I will start with Ms. Ina. So my first question is, does the Ministry of Justice have a dialogue with judges about the evidences that can corroborate the connection between those entities and Russian Federation? Do you have a strict algorithm for identifying such connections? And do you experience any resistance whom you accuse of the connections with Russia? And if so, can you give us some examples? So let's go question by question better, or at least speaker by speaker. About dialogue with the court, within the framework of court proceedings, we prepare the evidences and we submit the evidences. The court evaluates the evidences and the court resolves on the eligibility of such evidences. So there is practice. We create history right here, right now, online, because the majority of court hearings are open. You can watch them online. By the way, the hearing of High Anti-Corruption Court on the Ripaska case will be happening on 17th of May. Everybody who wants to be present, they can be present right in the hall, or otherwise you can check the live broadcast from the court. So it's about the eligibility of the evidences which is being discussed during the hearings, and this is how we create the practice. As to the resistance, no, the second question is about the strict algorithm to identify such connections. Well, it's the same story more or less. In the beginning of our work, we were all reliant on our expertise. There are some lawyers with an extensive court expertise. There are lawyers who were working in law enforcement agencies. They have some experience in this area, and this is what we were building our first steps on, to identify the connections. But now we have some algorithms, some procedures, what we should do before the NSDC resolution comes up. So we have such algorithms built. Every case is obviously unique, and comparing a case of a Duma deputy who was voting openly with the case of some entity under sanctions who are not publicly exposed, those are different cases, and obviously different procedures are being used, different methods are being used to identify or to find the proper information which we rely upon in our suit. So there are different cases and there are different methods, and depending on what information we receive upon our first applications, we try to see to what extent this information is verified, and it can serve as the precondition for the lawsuit. And sometimes with the help of law enforcement agencies, including law enforcement agencies from abroad, because there are some assets abroad, and relevantly the information, respectively the information about them is abroad. So there are some complicated and unique cases, but again the procedure is in place. Well, as to the resistance, you can see during all those open hearings, in every operating asset, every operating business, there are representatives of the opponents, and they protect their position, they submit their evidences, they try to explain. As a rule, they're trying to prove that the assets are not owned by the entities under sanctions. As I already mentioned, the entities under sanctions, they camouflage their connections to those assets in Ukraine, and this is the most complicated and this is most intelligence consuming work. And so our dispute is just to prove that this person, for example, owns that asset indirectly. And outside the court hall, do you observe any media campaigns, pressure, threats, I don't know, some cut pig heads at the door of Ministry of Justice? Well, we have not reached that phase of pig heads. We will react to such cases, obviously, but there were interesting publications when that it's a proper Ukrainian investor, or there were conversations in Facebook when we were being attempted to be convinced that if a person acquired a 75% of a Titan factory for 300 and something, for 3,000 and something euro, just 4 days before the beginning of full-scale invasion, they should be viewed as a proper Ukrainian investor, and we will protect ourselves in international courts. So, and we react. Yeah, there are discussions like that, but they are going on in a democratic way, fortunately in a democratic so far. So there were no cases of some illegal pressure that you mentioned. Well, then another question is to Mr. Hlib and Mr. Roman, and if you could be the most concise possible, what's your evaluation of the work of Ministry of Justice in terms of confiscation of Russian assets? Well, my evaluation is positive. I think that this work should be reinforced, because everything that can be enforced within the legislation of law, it can be happening only during martial law. After martial law, this procedure will be unavailable, and in our opinion of the civil society, if all of the big assets of the Russian capital or Russian oligarchs, they are not confiscated during the martial law, they will remain after the war, and they will continue influence our Ukrainian agenda. Roman, well, I would like to get back to our register to answer your question, because there you can see the concrete results in terms of confiscation. And talking about evaluation, I think that the things that we can see in a register, the positive things happen in the confiscation of Russian assets and the transition to fund of national property, it's the evidence that there are results of our work, and those results should be reinforced further on. And comparing the experience of our communication with other government bodies in the context of confiscated Russian assets, in case of Ministry of Justice, for example, we see cooperation, we see feedback, we see publicity, we see transparency, which is an evidence that this ministry is aiming at certain results, and these can be tracked in the register, and we will further on document those confiscations and cover them. And the last question is to all the panelists. So what should be done to improve the efficiency of confiscation of Russian assets? Thank you very much. I should have said this in the very beginning, but I digressed a little bit from this main subject that I should cover. So in brief, just a couple of words about the amendments to the law. First thing that we don't have in Ukraine, it should have been done 10 years ago, is the state register of sanctions, because the blocking sanction is the first sanction to keep those assets of the entities under sanctions in Ukraine, so that they cannot move them outside Ukraine. To have the blocking sanction work properly, there should be the register in place with all the identification details of those entities, if they are individuals, so it's the date of birth and all the necessary details since their birth. This register should be public, it should be open, it should be operating 24/7, and that register, I hope, will appear soon, because Ministry of Justice stepped up as one of the initiators of the draft law 8372, which is supported by the committee and recommended to be adopted in the second hearing. So I hope that time which we still have until this register appears and starts operating is the matter of months. Another function, another thing that I would like to see in this register is to have those entities under sanctions to be highlighted in all the other registers as highlighted as an entity or a person in relation of whom the sanctions are imposed. So every bank who have access to that public register during their operation, as they enter any identification details, they see that the person or the entity is highlighted as somebody who is sanctioned, so they can check which sanctions are already imposed, and if there is a blocking sanction, they should be refused any operations which contemplate disposal of their assets. So this is why this draft is very important, and I'm requesting for the public support for this draft law to be signed by the President. Another draft law, it's still being considered by the Parliament, 9235, which enables Ministry of Justice to disclose the bank's secret for the sake of confiscation of the assets, because the bank's secret is being disclosed under the banking legislation. And to receive the information about funds in the accounts of the entities under sanctions, we have to go to the court to get the judgment from the court, and then go to those banks, to all those banks which are listed in the judgment, then get the information about the funds, and then get back to the court proceedings. And in one case it happened so that even with information about the funds in the accounts of such entities, we were not able to increase our
demands during the court procedure, because we were in a phase where we could not do so. Well, it's not a horrible situation, we will finalize that process, but we will reapply again. We will resubmit again to the court with the additional assets, so we will finally enforce them in favor of the state, but it just lengthens the process. So should we be able to get the information about those funds before the process, this additional step to another enforcement of that assets wouldn't have been necessary. We all, as the Anti-Corruption Court, Ministry of Justice and StateWatch, we wouldn't have spent more time on that. Another important initiative to be implemented is the draft law 8384, which contemplates liability for making way around sanctions. So just until the very moment that we stipulate criminal liability for evasion of sanctions, we will have disorder in this sanction field, because when sometimes you have freedom to do something, whether the sanctions were imposed or not imposed, so it's the space for gray schemes, so to say, because if you help the entity under sanctions to evade those sanctions, then you should be liable under the law for your actions. And such criminal liability should be used against such entity under sanctions for attempts to evade the sanctions, like to re-register their asset. So if you do this, you have to be liable not within the framework of the sanctions law, but criminal law. For example, that asset that we mentioned that was confiscated in the United States and which is transferred to which is being transferred to Ukraine, it was confiscated under within the framework of the law of evasion of sanctions. So there is no such mechanism of confiscation of assets abroad for the time being, but there is a mechanism to confiscate the asset when an entity tries to evade the liability. This is the case when such asset may be confiscated in favor of Ukraine in this case. Mr. Serhii, what's your opinion? You work with the broad analytic massive of information. In your opinion, what can improve the efficiency of those processes? Thank you for the question. I think that publicity to the maximum extent, the most frequently, the open details. Unfortunately, such publicity of this central register stopped from the February last year, and it hinders to the significant extent to find the Russian historic trace, and also hinders re-registering of those assets. Thank you very much. And Hlib, in our opinion, well, on behalf of the public, we would like to add that we need to set priorities in the legislation. Who should be the first to be enforced the assets, because the resource will never be sufficient to make sure that during the martial law all those hundreds of persons that their assets are being enforced. So on part of Analytics Center of StateWatch, we try to pursue this idea, we try to promote this idea that the priority should be set by the Cabinet of Ministers, for example, of Ukraine, that there should be indicators, and we should prepare the suits with regard to such entities or persons who have strategic companies, strategic businesses in defense and security, airspace, banking. They should be the first to to be enforced. But then, for example, people who have some real estate, flats, houses, land plots, that type of property can wait. So the priorities should be viewed, or otherwise they should be set forth as a law. But as we see, the parliament, they cannot solve all the issues using the law, so we have to find a balanced solution. What I would like to add about the priorities, that there is an example when there is a company which manufactures plastic bags, for example, and there is a company which manufactures titanium and aluminum for export. Those are two very different types of activity, and the effect of those companies on the regions, and yes, they can influence the national security, yes, they can influence the security of Ukraine. So those are the priorities that should be evaluated, whether it's an active company or it's bankrupt and it's located in some decrepit building. So in that case, it's logical that the company should be enforced last or not enforced at all, because that would result in a burden. It will create additional problems for the country. So we should evaluate it from different sides by different factors. Thank you. I want to thank you for this wonderful conversation. I think we developed a lot of plans for the future that I hope will be implemented soon. Joining us were Inna Bohatykh, Hlib, Kenievskyi, Steblivskyi, and Serhii Milman. I appreciate the interest of my colleagues to this interesting topic, and we continue working on our victory. We thank our armed forces for this opportunity to hold events like this, and glory to Ukraine.